In the matter of Maharashtra State Road Transport Corporation versus Mahadeo Krishna Naik, Supreme Court ordered that Mahadeo is entitled to 75% of the back wages from the date of his termination till the date of his superannuation. This would be apart from Mahadev being entitled to full terminal benefits along with 6% interest had he never been dismissed from the service. The facts emerging from the perusal of records would reflect that Mahadev was appointed by the corporation as a bus driver on 19th April 1988. The incident which formed the genesis of present proceedings occurred on 10th May 1996. A lorry coming from the opposite direction collided at about 10:45 hours with a bus of the corporation driven by Mahadev, resulting in a fatal accident. Two passengers traveling on the bus succumbed to their injuries, while several others, around 10, suffered injuries. The monetary loss to the corporation rising from the accident was calculated at 45,000. The present controversy tasked the Supreme Court to address four issues: whether the corporation was guilty of Suggestio falsi by not disclosing what it had pleaded before the MACT, and Suppresio veri by suppressing the said award. Depending on an affirmative answer to the first issue, the second issue would be whether, in facts and circumstances, the single judge was justified in exercising review jurisdiction. Again, an affirmative answer to the second issue would require serious consideration as to whether any interference with the direction for payment of full back wages is called for or not. Fourth and finally, subject to the answers to all the three issues, what would be the appropriate relief Mahadev needs to be considered. The road accident, taking lives of two young children and causing injury to several others, had given rise to an FIR. Madhav was not named as an accused in that FIR. This fact was known to the corporation from day one of accident. The parents of Nitin Verdekar, a deceased passenger aged 17 years, had approached MACT with a claim for compensation under Section 166 of 1988 Act, and pleading with the corporation, the owner of the lorry, and the insurer of the lorry as opposite parties. The Latin phrases suggestio falsi and suppressio veri embody concepts of unethical conduct of a party having serious consequences in various fields, including law. According to Black's Law Dictionary, suggestio falsi is a false representation or a misleading suggestion, while suppressio veri connotes suppression of the truth, an indirect lie, whether by words, conduct, or artifice. It's a type of fraud. Corporation indulge in the misadventure of suggestio falsi and suppressio veri is incontrovertible. Before the Labour Court, the corporation did not leave any stone unturned to establish that not only was the inquiry conducted against Madheo fair, but the conclusion arrived at in course of such inquiry that Madheo was guilty of misconduct and rashly and negligently driving the bus of the corporation, leading to loss suffered by it, was established upon due consideration of the materials on record. Having regard to the clear and specific stand taken before MACT in its written statement, which has been quoted above, the corporation did make a false representation before Labour Court amounting to suggestio falsi. Also, having not disclosed before the Labour Court outcome of the proceedings before MACT, if fortiori that it had not been found liable to pay any compensation to passengers who either died and were injured based on what the version in written statement was, and the argument advanced on its behalf to absolve itself of any liability, the corporation is also guilty of suppressio veri. The conduct of the corporation when Mahadev was struggling to find a foothold before the single judge, in view of contours of judicial scrutiny of awards of industrial adjudicators, cannot also escape notice. The corporation was caught off guard when Mahadev produced the written statement and the award of MSCT before the single judge in his review petition. To be relevant, a piece of evidence relied on by a party must be shown to have some logical connection to the case, and its admission would necessary to prove or disapprove a fact. Once the evidence is found to be relevant and is admitted, arises the question of its probative value. Probative value is well known, refers to the weight or persuasive power of the evidence. It is not always necessary that a piece of evidence found relevant to a case would still demand significant probative value. An assessment has to be made by the court as to how convincing or persuasive the evidence is and how effective it would be to prove or disprove a fact. It also appears to us that the actions of the corporation were motivated. The track record of Mahadeo would show that he had been involved in 8 collisions before the collision with the lorry. Why the corporation did not get rid of Mahadeo before is best known to it. However, wanting to get rid of Mahadeo, the corporation on this occasion found a convenient excuse in the collision and went ahead to dismiss him in the most unfair manner. The courts may be confronted with cases where grant of lump sum compensation instead of reinstatement with back wages could be more appropriate remedy. The courts may in such case providing justification for its approach direct such lump sum compensation to be paid keeping in mind the interest of the employee as well as the employer. Mahadev has admitted in his counter affidavit filed before the court of being engaged in badli work or a daily wage basis. At the same time, it is specific his case that because his service was terminated by the corporation, he could not find a permanent employment elsewhere. There is no material on record to disbelieve Mahadev, since the exact quantum of wages earned by Mahadev is not available, and at the same time, it is clear as crystal that the corporation succeeded in its attempt to get rid of Mahadev by indulging in the misadvantage of Suppresio, veri, and Suggestio falsi. We are of the considered opinion that the interest of justice would be sufficiently served if, in modification of the order of the single judge awarding 100% back wages, Mahadev is awarded 75% of back wages from the date of his termination till the date of his superannuation.